Randwick Local Planning Panel on the 11th of May 2023. Firstly, I would like to acknowledge that we are meeting on the land of the Bidjigal and Gadigal peoples, being the traditional owners, and pay my respects to the elders past, present, and to Aboriginal people in attendance today. I'm the chair of the panel and my name is Annalise Toole. Joining me today via video conference are Julie Sabat-Ward, Cara Cranson as expert members, and Kerry Hamer as the community representative. Today we have 5 people registered to address the panel. Each speaker will be given 3 minutes. Any extension of time will be at my discretion as chair. After hearing from the speakers, the public meeting will be closed and the panel will deliberate and make our decision. The minutes of the panel decision, including our reasons, will be available on Council's website as soon as possible after the public meeting. You should be aware that panel meetings are recorded and the audio recordings will be placed on Council's website. Each member of the panel has been asked prior to the meeting to advise whether they have a conflict of interest to declare in relation to the item on today's agenda, and I can confirm that no conflicts of interest have been declared. So the item on today's agenda relates to 3 Berwick Street, Coogee, and we have 2 councillors. The first councillor is Councillor Kathy Nielsen.
Thank you, Chair. I agree with the officer's recommendation for refusal. The heritage significance of the site, of course, adds weight to the decision to refuse the DA. However, the fact that the DA itself is non-compliant, as the report clearly sets out, namely the proposed DA is of an excessive height and the proposed development would result in adverse impacts on neighbouring properties, the streetscape and occupant amenity, and the excessive gross floor area, which further contributes to an excessive level of built form on the site and detrimental visual impact. And the proposed development would result in an excessive level of bulk and scale on the site and is inconsistent with the existing and desired future character of the streetscape and the locality. I urge the panel to refuse the application. Thank you, Chair.
Thank you. Any questions from panel members?
No, thank you.
Thank you. We now have Councillor Michael Olin.
Thank you, Chair. I too urge the panel to refuse this application. 1, 3 and 5 Berwick Street are a cluster of interwall buildings. Interwall building on the Berwick estate and much loved by the community. The current proposed development for 3 Berwick Street is not in keeping with the history of the site and is opposed by the community. The community have expressed their opposition to this development by large crowds attending for the Land and Environment Court on-site inspection, the number of submissions to this planning panel and the many resident contacts received by councillors. 415 Part 1E of the Environmental Planning and Assessment Act say that the Consent Authority must take the public interest into consideration. The public have expressed their interest, and that's not to build something at 3 Berwick Street that isn't sympathetic with the heritage of the location. Thank you very much.
Thank you. Any questions?
No, thank you.
Then we have an objector, Mr. Andrew Neenan.
Sorry, speaking. Can you hear me now?
Yes, I can hear you.
Yeah, thank you. Good afternoon, Madam Chair and panel members. You would have seen that a lot of written objections pointing out that the DA is not satisfying a lot of the key objectives that set out in the RLPP 2012. And I believe, reading through that, I know that I think the applicant know this, but they're still trying to push through using misinformation and spurious statements. And let me illustrate what I just said. I would like to use just one criteria, that is the adverse impacts on neighboring buildings, particularly myself. I live next door to that development site. This is only one example. I would like to share with you a diagram that an excerpt from the DA. you can see that, well, in the DA, they use ridge lines level, and they say that the ridge line levels are compatible to other buildings. Okay, I would like to go a little bit further into that by adding a few lines of myself to demonstrate what I'm saying. You can see that blue line I put in marked roof envelope line 1. It joins between the two ridge lines of number 1 barrack and number 5 barrack, and that is a transition of height that any building that claim that to have a transition of height between those two buildings should not stay above. You can see that this is not the case, but never mind that. It's more importantly, to me, I can point out that ridge line is irrelevant in this case. When you compare and you assess the impact of one building on another, you do not use ridge line. You use the height of the boundary walls. And what I'm showing to you, these are the boundary walls here, and the height of those walls that matters, not the ridge lines. Why? Because windows, normal windows, do not or are not located near ridge line. They are located on these walls and below the what I call a gutter line, which is this point and this point of the buildings. You can see that my windows will be way down here, and this is the window of my living room. The only source of direct daylight I have, and you can see that, see the height is different and they're very close together, and that's why it doesn't matter what the ridge line show you, my building or my windows will be under the shade and the shadow of this building anytime, any day of the year, regardless what they say about the ridge line. And you can see that. I will show you a next line, and you can see that this ridge line, you can see down here, a long, big line, very high, many meters higher than my windows. And it also, it starts from the back of the house to way in front, way past my front yard, my front wall here, go onto the front yard. And looking at this, I can talk very briefly about the setback. The applicant claimed that they have shifted their 4th floor front line back, and therefore it shouldn't be impacting on my house. Well, it doesn't make any difference because it's the way up here, it's the way in front of the front wall of my house, and so on. So it makes no difference. And by the way, if you look at this one, the level 3 of the proposed building, still many meter higher than street level. The street level is way down here and not very far from the front boundary. So that means when you're walking on the footpath along here, this building will be towering on top of you, very claustrophobic to say the least. That's all I can say. It is impacting badly on my property, regardless what you see in the application. That's all I have to have for now. Thank you very much.
Thank you. Any questions?
Actually, sorry, can I also, I happen to talk to the owner of number 109, which is of Mount Street, which is behind the development site. He basically expressed his very disappointment, and he was quite upset that he wasn't given the opportunity to express her concern as well. So I thought I'd just do that. Thank you.
All right, thank you.
I just had one question,
Yes.
if I may.
Yes.
Yes.
And Andrew, how long have you been in your house at number 5?
1 year. Sorry. Hello.
Yes, hello. We can hear you.
Yeah. Sorry, I can't. I don't know. 1 year, please. Yes.
Well, you've only been there 1 year. Okay.
Yes.
Thank you. That's all I want to know. Thank you.
Thank you.
Any other questions? No. All right, thank you very much. And then we have Morris Cunningham.
Microphone. And good afternoon, panel. Can you hear me?
Yes, we can.
Good afternoon, panel, Madam Chair, panel members, and the councillors. I'm going to be focusing on the, if I can share window. I have a PowerPoint I'm trying to bring up.
It's not up yet, but keep trying.
Clicking. Where's clicking? That's my computer. This might bring it up. Is that showing on the screen?
No, not yet. Is it something that you've sent to council?
No. Oh, here we go.
Okay, Chris, it's coming up now.
Yeah.
Yeah,
Right.
we've got it now.
Okay, just as an intro, we know that Coogee Village was actually started on the beach side first in the 1890s. And then the tram lines came through in the 1890s, setting up the beachside residence first, down around the actual, the hinterland of the actual bay. And then there was infill that came in the 1920s. And this is the area here, number 3 Berwick Street has got the number 2 and the red circle around it. But you see that it's a very prominent spot with Dr. Booth's house on the left, Dr. Thompson's on the right, which is still operating as a medical centre. And, but in our case, I'm going to be focusing on lot size. Now the LEP lot size map for this area has no lot size mandated. Now this means that there's no lot size required. However, clause 141B has the exceptions to this. And in subsection 2, you'll note that the minimum subdivision lot size for any lot resulting from the subdivision of a lot in zone 3, which this is, or is proposed to be used for the purpose of a dwelling house or for a purpose other than a residential accommodation is 325 square metres. A dwelling house is the only type of residential accommodation that minimum subdivision lot size goes to. Now, the development application seeks to propose that their lot escapes the provision for being 325 square metres for each lot by stating that a semi-detached dwelling cannot be defined as a dwelling house. This is wrong. Randwick Council provides in its definition, as you can see here, dwelling houses. The definition includes detached dwelling houses and semi-detached dwellings. They may or may not be attached to one another by a common wall. The semantic sidestep of the applicant cannot avoid the clear definition of Randwick Council that the term dwelling house includes detached dwelling houses and semi-detached dwelling houses. The applicant's claim is fundamentally incorrect. The council paper, though, errs in its interpretation and conclusion in this regard at page 19 of D28/23, where it only quotes the definition of semi-detached dwelling. It limits it to a definition of semi-detached dwelling, but it does not state that a semi-detached dwelling is not or cannot be considered a dwelling house. It goes on to purport that given that a semi-detached dwelling is a type of residential accommodation, not disputed, and not a dwelling house, this clause does not apply. The council paper does not elaborate on how it comes to this definition that a dwelling house, a semi-detached dwelling, is not a dwelling house. It's a misconception by this construction, which derives the meaning that a dwelling house is not a type of residential accommodation. It is not disputed that semi-detached dwellings are residential accommodation, but this does not mean that they are not dwelling houses, which are also residential accommodation. The dictionary definition of residential accommodation shows that it includes dwelling houses and semi-detached dwelling houses. It is proposed that these lots are for residential accommodation and that as semi-detached dwellings, they are also classified as dwelling houses. The This is supported in the New South Wales State Environmental Planning Policy, where it states that a dwelling house means a building containing one dwelling, an attached dwelling, or a semi-detached dwelling. A clear definition used by the State Environmental. Further is the, which I haven't got a slide for, but the New South Wales Housing Code holds a definition. Dwelling house means a building containing only one dwelling, an attached dwelling, or a semi-detached dwelling, but does not include any part of the building that is ancillary development or exempt development under the code's SEPP. That's in the Guide to Complying Development Housing Code, State of New South Wales, April 2011. Thus, the development application cannot claim to avoid the RLPP requirement that the minimum subdivision lot size for any lot resulting from the subdivision of a lot in zone R3, medium density residential, which this is, that is being used or proposed to be used for the purpose of a dwelling house, which it is a requirement of 325 square metres. The proposal is seeking to have lot sizes of about 168 square metres, well below the 325. Definitions are given both in council and legislation that a dwelling house includes a semi-detached dwelling. I maintain that the clause does apply as a semi-detached dwelling is a dwelling house under the definition of the RLPP, council definitions and state provisions. This fundamental failing of the development application should not allow it to proceed. And just by following up on Andrew at number 5, that's number 5, and that's his roof line now. And you'll notice from those previous diagrams, they were intimating that the roof lines were all going to be the same. My building is number 1. It's a 1926 building. Plans were approved by council in 1925. It's a duplex built as a wedding present. The father didn't believe the marriage would survive, and it didn't. And the other level provided income for Mrs. Schrader in future life. We've been in that.
I'm just going to interrupt you because you are over time. So,
I was just going to say, given the previous question, we've been, Cunningham family have been in the house since 1965, and Mrs. Schrader was in there from 1926 to 1965. So there's only been two families in there in that period. And I thank the panel for their consideration.
All right, thank you. Any questions from panel members?
No, thank you. Thank you.
Thank you.
Thank you for the visuals.
Yes, thank you. And now we have a representative of the applicant, Mr. Tone Wheeler.
Thank you very much, panel. I believe under the rules of your panel, I have the same amount of time as each of the objectors. Is that correct?
No, you've got 3 minutes, but given that there were more objectors than normally it's 1 for and 1 against, I'll allow you extra time. How long do you think you need?
3 minutes will be fine.
Pardon?
3 minutes will be fine, I think.
Okay, well, if you need more time,
I'm sure you'll have questions after that. I wonder if we could remove that from the screen, please.
Yes, if you could stop sharing, Mr. Cunningham.
My 3 minutes hasn't started.
No, your 3 minutes hasn't started yet. Okay. Your time starts now.
He's frozen.
Oh no, we've got everyone frozen now.
Oh no, not everybody.
I think it's just time.
It's just time. It's
Okay. I don't think there's anything we can do at our end.
Susan knows it's frozen.
I presume he's aware that he's frozen. I would say so.
Have you got contact?
Yeah.
Yeah, just to let them know. You may have to log out and log back in.
Yes.
His number is on the plan.
Logging out and logging back in is generally the way that resolves it.
John called him outside.
He's doing that.
hear you.
Yeah, looks like he's doing it.
Okay, great.
Yeah, there we go.
Okay, good. Try again.
Did someone let him in?
Oh, good.
There was someone waiting in the lobby.
That was.
Well, that
Mr.
might
Cunningham.
All right.
Yeah, why don't we try?
Yeah.
It's got the names. So 9211 0000.
Yeah, that might just result.
Yeah, is there a company
Well,
involved?
he's the only person.
9211
The
2219.
So 9211.
Oh, sorry. Yeah, 11 and 0000. That's the only contact.
When people register, do they always give a mobile as well? So there's no requirement to give a contact number. It's probably a good idea to actually get a contact number.
What we have is
Emails.
on Zoom.
Clarinet's here.
So you're back?
Are you in?
So Ms. Wheeler, are you there? Can you hear us?
Yes, we can. Just give us 2 seconds.
Sure.
All right, let's make this really quick.
Yeah, your time hasn't started yet, so your time starts now.
I can't set his place. That's right. Okay.
Yes, camera's on.
You're not risking
You've provided a development application report, D2823. It has 12 points in the recommendation, 7 of which refer to heritage matters, which are currently before Commissioner Dixon at the Land and Environment Court. We don't have a judgment on that yet, so let's just set those 7 aside for the moment. Then there are 5 other matters that deal with height, built form, bulk, and amenity. So my proposal to you is this. We've designed this building in accordance with the Randwick LEP and the DCP. We take great note of the controls that are implied, which are the only way in which we can understand the built form anticipated for the subject site. So it's medium density housing. A RFB is permitted. So you could have a residential flat building, which is indeed the previous application that was made. So a pair of houses is entirely permitted on it. The whole rigmarole about the size of the site is completely irrelevant and is dealt with at page 33 in the planner's report. So it's permissible use, it's a permissible buildings. What we're trying to do is create two houses where there is only one, which is part of the affordable housing component in the state government's approach to trying to increase the density of housing within existing suburbs. Now, I'm a big subscriber to all of that, as you probably know if you read the Sydney Morning Herald, and I'm taking this chance to increase a rather dilapidated old house that covers most of the site and build two houses which are taller but less in area, providing off-street car parking for two cars and being able to provide a bigger rear yard than is currently there to allow more light into the surrounding buildings such as 109 and 111 Mount Street. So the idea that I have is in fact to aggregate the building into a smaller footprint, and yes, it makes it taller. Provision that we're providing is a house, a conventional house with living room on the ground floor and then bedrooms on 2 levels, separating out a sort of parents area and a children's area in the building. I think the biggest issues that we face here are one of height. We've put in a clause 4.6, which I think is very well argued, but council invokes 425 versus Ashfield, and there's no way of arguing that in 3 minutes. So let me make a proposal that what we would do is actually address each of those 5 elements that are in that report by complying with each one of them. So we pull the building back down to 9 meters, which we can do by changing the roof form. We can change floor to floor heights. We can do a number of things to it, remove the roof over the balcony at the front of one of the 2 houses, which is the main offending one. So we can actually change that and we can comply with the height. We can comply with the wall heights. We're 1.5 meters over wall height. We think that's quite reasonable to do because you end up with a reasonably clean, contemporary form of the building, of vertical parts with a pitch roof that picks up on the pitch roofs of the adjacent buildings, the gable end form of the existing building and the building at number 5. But we can alter that to meet the code exactly. If council's not convinced that this minor discrepancies to the controls cause it to fail entirely, then we can make it conform to the controls. So you can change the wall heights, you can change the overall height of the building. There is no GFA, there's no floor space ratio in this area. And the height limit's 12 meters for all buildings other than a single house or a duplex. So clearly the thought behind council in what is the built form anticipated for the subject site is actually something that would be reasonably large and reasonably tall. Otherwise you would have put an FSR in there, and otherwise you would have a 2-story height limit, 8.5 meters. So clearly you're anticipating a building of this bulk and of this scale. And I think that if we were to comply with the numerical values in terms of height, setback, which we already comply with in the front, we have arguments about what's at the rear, but we would maintain that increasing the setbacks from the miserable 1 meter of the existing building to provide a reasonable garden and therefore more light to the surrounding buildings is a better outcome. And we think that would meet the numerical codes, and then we're down to an argument about whether the building is sympathetic to the location. I refer you back to what I just said. I think the LEP and the DCP envisage a building of this kind, of this type. There is no amenity issue in there about the aesthetics of the building, from what I can read, what I can understand. Because I think you'd accept that we're trying very hard to make a building which is a contemporary in form, but an interpretation of what is in the surrounding area, which contains apartment buildings, single houses, some quite intrusive 1970s apartment buildings and some other mixed use in that area. There is no consistency. There's no consistency in rear setback. There's none of the buildings in that area conform to the height of wall area and setback once they get over 9 metres. There are 5-storey apartment buildings there. There's a whole mix of things on Mount Street and on Berwick Street that mean that it's very hard to find some consistent context into which we're putting it. So we're just trying to be neat, withdrawn from both sides. We're not built to the boundary. It's a setback. It allows air on both sides. Setback's exactly the same as number 1. On that side, it has a form which is rather assertive by going up from the basement level, goes up and creates the pediment, if you like, the cable end of it. But none of that actually seems to be of an issue to council. So if we set aside the 7 things to do with heritage, and then you say, well, look, the 5 numerical things that you've raised could all be addressed in an amended. And I seek leave, therefore, from the local planning panel to defer consideration of the matter so that we might provide an alternative solution to the building. And given that we don't yet know what the outcome of the application at Land and Environment Court might be, perhaps we might defer this for those 2 reasons. Obviously, if the Commissioner rules in favour of council and a heritage order, interim heritage order, then all of this is moot. If, however, Commissioner Dixon rules in favour of the applicant ourselves, and the DA is then on foot, we would prefer that we have the right and ability to be able to amend it now that we have a very detailed document from yourselves. We've not had time to consider it in its complete detail, but I believe that I'm making a fair and reasonable offer to council to make it meet the numerical conditions and to go back and therefore withdraw the 4.6 because it won't be necessary, and to address the various amenity issues in your planning report. That's my summary. Thank you.
Thank you. So in terms of essentially you're asking for a deferral. What time frame would you be looking at for that deferral?
There's 2 parts to that, Chair. I think we don't know what the outcome of the court case is, but I would like to say that should it be in the favour of the applicant, we would make an application back to council within 2 weeks of that.
So you wouldn't do any amendments until there's a decision from the court, which could be a couple of months away still.
Well, it's all a bit moot, isn't it? I'm more than happy to make amendments to these drawings and to give you an amended submission, and we would do that within 4 weeks if that was acceptable to you for consideration.
Yeah, because potentially they may need to be re-advertised depending on the extent of changes, et cetera, et cetera.
Look, I have no doubt that we would want it to be re-advertised because we're not going to go to the effort of reducing the height, reducing the bulk, reducing the wall heights on the edges, and making substantive changes to the building without that being conveyed back to the community who have such opposition to this proposal.
And this is a bit of a technical question, but the need to defer it as opposed to us dealing with it on the basis of the report before us, and then potentially, if we were to refuse it, you then coming back with a Section 8.2 review. What's the sort of pros and cons of that approach?
I'm always in favour of negotiation with council. My client and my barrister and my solicitor disagree. So I would prefer that you do, for whatever hoops you have to jump through, defer this so that I might make a further design changes to this. And if you want a shorter time frame, we can attempt to do a cut down version of that DA in that time frame in order to negotiate with council, rather than to, I mean, if we take a refusal, we're immediately going to, you know, lodge for a Section 34 at Land and Environment Court. I mean, a very quick review of my my history will show you that that's what this client and myself would do. I'm trying to avoid that. I mean, we've had to go to court in order to put an injunction on the IHO, but otherwise we rather negotiate with council to find. I mean, I'm sensitive to the need of the local community to have something that's there, that is going to be built and is going to be used, and that they will understand that it is in fact legal, that it is conforming to the LEP and the DCP, and that it does provide additional housing in that area, and it provides good quality housing. It provides off-street car parking, and it provides gardens and landscape and more deep soil than is on the site at the moment. And it meets obviously all the modern conditions for basics and natters and so on. So in other words, it is improved dwelling, and there's two of them, and I'd rather negotiate with council on that rather than sit across the table at a Section 34.
Any questions?
The one question that I do have, Mr. Wheeler, normally when a panel defers an application, it is to address some very minor and specific issues, and it wouldn't normally go back out to public exhibition. I hear what you say, that you would like a public exhibition so that the community understand exactly what is proposed and what the amendments are, but that would be unusual in a deferment or deferring a panel decision, because the process is that you defer, get some specific changes done, and then it comes back to the same panel for consideration and a decision. Whereas the approach you're suggesting is opening it out to community consultation again. Which is quite different to the way one would normally defer consideration of a DA.
Just interrupting the earlier decision about whether it needed to be re-notified would be based essentially on the requirements of the DCP.
Yeah, I'm just commenting on what Mr. Wheeler's saying. It's more in terms of wanting the community to understand. Sure. And indeed, I understand why you would do that. But it is different to the normal intention of deferring a DA.
I think the difference here is that in almost all cases of applications before many councils I deal with, there is some report or some negotiations with council prior to it going to the LPP or whatever planning panel is there. And that hasn't happened here, to my knowledge. We've had no opportunity to discuss the matters and put forward our case until now. Whereas in almost all cases, as you would know, we have a lot of work in the Inner West Council and with the City of Sydney, and we would always have a meeting with them, and now it's back to being in-person meetings in order to discuss the DA with the relevant planners and engineers and so on, as a discussion with a view to perhaps making amendments. Now, given that interim meeting and discussion hasn't happened, and my guess is that hasn't happened because so much of it's been to do with the heritage, and so much of this process is related to the heritage issues. We've not had that interim. This in effect is our interim discussion. And so I'm asking for the same treatment that I would have at an interim discussion in order to be able to amend the application.
Did you have any RFI sent to you, a request for information?
No, we're not aware of any, no. I'm referring to my project admin officer, and we'll look through the files, but no, I don't believe so. I mean, I'm proactive to that because that's my favourite part of the whole project, is to actually sit down with professional planners and architects and negotiate what's the best outcome for the site, the suburb, the LGA. Yeah.
So, Mr. Wheeler, you didn't have a pre-DA meeting with council?
No, I didn't. I have a particular view on pre-DAs that doesn't need to be ventilated here.
Okay, I have no further questions.
Mr. Wheeler, I'd just like to ask a question about height. I recognise what you're indicating, that you'd like the opportunity to go back and make some adjustments, and I think you said that you believe that you could have a fully compliant scheme where there would not be any variation to height limits sought. I was curious when I saw the plans on why there was a difference in height between the two dwellings, but I guess in terms of what your thinking is in relation to coming back with a compliant scheme, you can see that the top floor in particular obviously has quite significant floor to, I guess, roof height. In reducing that height, would that also mean that, how would you deal with the lift overrun? Because at the moment, you've obviously got that very high floor to, it goes beyond ceiling, goes floor to roof height, and your lift overrun is captured within that. So in terms of reducing the floor to floor heights of, I guess it's the second and the third floor, not the living level, would you still be able to achieve a fully compliant scheme inclusive of the lift overrun or any other structures that fall within the height definition? Yeah,
it's a curious thing, isn't it, that as we've got further on in the century, we are wanting lifts in private houses, which means that there's now a huge industry that provides those lifts. And there's now a lift operator, lift maker, who can provide for the last floor of the lift to be only 2.4 meters tall. So it would fit underneath it. The previous it was 3.3. It was 3.6, then 3.3, and there's now a lift which we're using on another site, but that does require a lift in order to operate, because it's a 5-story house on this foreshore, on the edge of a cliff in Seaforth. But that's not here. I could go back to my clients and we could negotiate whether we have a lift at all, if that's an issue. Put simply, what would happen is, I think that the top floor of the building will be somewhat reduced in width in order to meet the height requirements and the setback of the boundary walls. Therefore, if it's reduced in width, so the gable will come down, and then the gable at the front of the building would be removed and replaced with what I had wanted to do in earlier schemes, which is to provide a horizontal veranda similar to the existing building, so that there is a gable end on the end of it, and then there's a horizontal roof at the front, so there's a bit of horizontality introduced to the verticality of it. And then by manipulating the room arrangements there, the parts of it that are under height would be the service rooms. And then there's an allowance for things which are underneath the pitch. We'd have a cathedral ceiling, as they're called, although it's hardly a cathedral if you've seen the coronation. So I think there is a way in which those existing layouts and plans can be modified to be compliant.
And in relation to any of that early testing that you might have done, have you at this stage gone to the extent of looking at, if you did those things, whether that would have any beneficial impact on the overshadowing that was mentioned by the neighbour at number 5?
No, I don't have a numerical value for that, for Andrew, I think it is at number 5. But I can see that we would certainly have some impact on that because the walls would be coming in closer and they would be lower in height, and the whole building would be lower over height. So I'm sure that there would be lesser impact from that. But you know, given that the houses are facing north, essentially, you know, that's where you're deriving your sun from. We would expect that it's the afternoon sun that would be improved.
Thank you. No further questions from me.
No, I haven't got any questions.
All right, so that's our questions. And that concludes the public meeting. As I said in my opening, the public meeting will now be terminated and the panel will go into closed session to consider this matter. Our decision and our reasons for our decision will be placed on Council's website as soon as possible. So thank you all very much for attending. And the meeting is now closed.
Thanks very much.
Thank you.
Thank you.
Thank you.
Thank you.